Stop right there. Before you say I do or sign those divorce papers in 2026, there's something absolutely critical you need to know. The legal landscape of marriage and divorce in America has shifted dramatically, and what worked for your parents' generation might cost you everything today. Whether you're planning a wedding, navigating a rocky marriage, or considering separation, the next 15 minutes could save you from making a devastating mistake. I'm talking about real changes that affect prenups, property division, alimony, and even how social media posts can be used against you in court. So stick around, because by the end of this video, you'll understand exactly how to protect yourself under the new rules.
Hey everyone, welcome back to the channel. If you're new here, I break down complex legal topics into information you can actually use to protect yourself and your family. Today, we're tackling something that affects millions of Americans every single year: marriage and divorce law. And let me tell you, 2026 has brought some serious changes that caught even experienced attorneys by surprise.
We're seeing shifts in how courts handle digital assets, what makes a prenup enforceable, how alimony gets calculated, and what factors determine custody arrangements. These aren't small tweaks. These are fundamental changes to how the legal system approaches relationships. And whether you're happily married, engaged, or going through a separation, you need to understand what's different now.
So let's dive in and break down everything you need to know about the new rules governing marriage and divorce in America. Marriage and divorce laws in the United States have always been complex, but 2026 has brought a wave of updates that every couple needs to understand. These aren't just minor adjustments to existing legislation. We're seeing fundamental shifts in how courts handle everything from digital assets to cohabitation rights, and the financial implications are absolutely massive. Let's start with one of the biggest changes that's catching people completely off guard: the evolution of prenuptial agreements. For decades, prenups were seen as something only the wealthy needed to worry about. That mentality is officially outdated and could cost you dearly. Courts across multiple states are now enforcing much stricter standards for prenuptial agreements, which means the document you signed 5 years ago might not hold up in court today. The new requirements focus heavily on full financial disclosure and independent legal representation. What does this mean practically? If you signed a prenup without each party having their own attorney review it, there's a significant chance a judge could throw it out entirely. We're seeing cases in California, New York, Texas, and Florida where prenups are being challenged successfully because one party claims they didn't fully understand what they were signing or didn't have adequate time to review the terms with independent counsel. Here's where it gets really interesting. The recommended waiting period between presenting a prenup and signing it has effectively doubled in many jurisdictions. Courts are now looking for at least 60 days between presentation and signature, and they want to see clear evidence that both parties had meaningful opportunity to negotiate terms. If you're planning a wedding, this means you need to have these conversations much earlier than you might think. Gone are the days of presenting a prenup 2 weeks before the wedding and expecting it to hold up. If you're making money from YouTube, Instagram, TikTok, or any other platform, that's now considered a marital asset in most states, and it's subject to division. Some states are going even further, requiring cryptocurrency to be converted to traditional currency before final divorce settlements. This prevents situations where one party receives crypto that then crashes in value, while the other party walks away with stable assets like real estate or cash. The volatility of digital currencies has created so many post-divorce disputes that judges are simply removing that variable from the equation entirely. Alimony laws have also undergone significant reformation across the country. The old model of permanent alimony, where one spouse pays the other indefinitely, is virtually extinct in most states. What we're seeing instead is a major shift toward rehabilitative alimony with clear timelines and specific objectives. The underlying assumption is that both parties should become self-sufficient within a reasonable time frame.
You can't simply maintain separate addresses if you're essentially living as a couple. Child custody laws continue to evolve rapidly, with a strong preference toward shared parenting arrangements. The default assumption in many states is now that 50-50 custody serves the child's best interests unless there's compelling evidence to the contrary. This represents a major departure from older models that typically designated one primary custodial parent, with the other receiving visitation rights.
What's particularly interesting is how courts are now evaluating parental involvement. It's not enough to simply want custody or claim you're a good parent. Judges are looking at historical patterns of participation in the child's life. Who attended school conferences? Who managed medical appointments? Who helped with homework? Who handled the day-to-day logistics of raising the child?
If you're hoping for significant custody time, you need to demonstrate consistent, meaningful involvement in your child's daily life, and that evidence trail starts long before you file for divorce.
Social media has become a critical factor in custody determinations, and this is where many people shoot themselves in the foot. Posts, photos, check-ins, and even private messages can be subpoenaed and used as evidence in court. We're seeing cases where a parent's custody arrangement was dramatically affected by inappropriate social media activity.
Posting about partying when you claimed to be focused on parenting, sharing disparaging comments about your ex, or displaying concerning judgment online can all work against you in devastating ways. Property division rules have been updated to address modern assets and modern relationships. The concept of marital property versus separate property remains, but the lines are blurrier than ever. If you owned a home before marriage but your spouse contributed to renovations or mortgage payments, that separate property may have been converted partially to marital property through their contribution.
Inheritance and gifts received during marriage are generally still considered separate property, but commingling creates serious complications. If you deposited an inheritance into a joint account and used it for marital expenses, you may have inadvertently converted separate property into marital property. The burden is on you to prove what assets should remain separate, and that requires meticulous record-keeping from day one. Business owners face particular challenges in this new landscape. If you started or grew a business during your marriage, your spouse likely has a legitimate claim to a portion of its value, even if they never worked in the business. Courts are now using sophisticated valuation methods and often appointing forensic accountants to determine fair market value and each spouse's contribution to that value, whether direct or indirect. Retirement accounts and pensions continue to be among the most contested assets in divorce proceedings. Recent updates to how these accounts are divided focus on ensuring both parties maintain retirement security. Courts are more likely to use formulas that account for both the length of the marriage and the total time of employment, creating more equitable outcomes for both parties.
Domestic violence protections have been strengthened significantly, and this is genuinely positive progress. Restraining orders are easier to obtain, and the definition of abuse has expanded to include financial abuse, technological stalking, and coercive control. If you're in an unsafe situation, understand that you have more legal protections than ever before, and courts are taking these allegations more seriously than in previous decades.
Look, nobody gets married planning for divorce, but understanding these legal realities isn't pessimistic or cynical, it's simply smart.
Whether you're engaged, married, or considering separation, knowledge is your greatest asset in protecting your future. These 2026 updates aren't designed to make your life harder. They're meant to create fairness, protect vulnerable parties, and address the realities of modern relationships that the law hasn't historically kept pace with.
If you found this information valuable, do me a huge favor and hit that like button so the algorithm shows this video to more people who need this critical information. Subscribe to the channel because we break down complex legal topics into plain English that actually helps you make better decisions for your life and your family. Drop a comment below telling me which of these updates surprised you most or if you have specific questions about your situation. I read every comment, and your questions often inspire future videos.
And here's my most important piece of advice. Don't try to navigate these waters alone. If you're seriously considering marriage or divorce, consult with a family law attorney in your state who understands these current regulations. Laws vary significantly by jurisdiction, and what I've covered today are general trends and updates, not specific legal advice for your unique circumstances.
Your financial future, your relationship with your children, and your peace of mind are too important to leave to chance. Arm yourself with knowledge, surround yourself with qualified professionals, and make decisions from a place of clarity rather than emotion. Thanks so much for watching, and I'll see you in the next video where we dive deep into estate planning mistakes that could cost your family everything. Until then, take care and stay informed.